On the record in case number 2020-CR466, captioned State of Kansas versus Tremon Davis. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Claire Thibodeau.
Good afternoon, Your Honor. Tremon Davis is present today with his counsel, Raymond Probst. We are both appearing via the Zoom platform.
All right. We are here set down for a plea hearing today. Mr. Davis, I need to ask you a bunch of questions to go over your plea with you. If I ask you something you don't understand, you tell me that, and we'll talk about it until we're both sure that we're on the same page, okay?
Okay.
All right. And if at any time I ask you a question and you want to talk to Mr. Probst in private before you answer, you just tell me that, and we'll do the same thing we did before we came on the record here today, okay?
All right.
All right. To do this, I'm going to need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
You solemnly swear the testimony you're about to give in the cause now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, go ahead and put your hand down. Mr. Davis, how far did you go in school?
12th grade.
All right, you read and write okay?
Yes, sir.
I know you're in custody, but as you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what we're doing?
No, sir.
All right, feel like your mind's clear today?
Yes.
You know what you're charged with?
Yes.
All right. And you understand you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial. Do you understand that?
Yes.
All right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Probst would assist you throughout that trial. He would confront and cross-examine all the state's witnesses. He would challenge all their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use subpoena power to make them come to court. At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you to argue you must be guilty. You understand all that?
I understand.
All right. Now, if we had that full trial and at the end of that trial you were found guilty, you would have a right to appeal that conviction to the appellate courts. If you didn't have money to do that, a lawyer would be appointed to do it for you. You understand that?
I do.
All right. If we go forward with this plea today, you're going to be giving up all of those rights, and there's not going to be a trial of any kind in this case. You understand that?
I do.
All right. Now, I know Mr. Probst didn't get to see you personally, but I'm going to pull up my screen here and show you what he sent me that purports to be your plea petition in this case. Does this document look like the one that Mr. Probst just went over with you?
Yes, sir.
Okay.
Your Honor, just for the record,
Yes.
I couldn't actually show it to him because I didn't share the screen, but I did read it to him word for word and asked him about each paragraph. But he has not actually seen the plea petition, but he was read the plea petition.
Okay. And Mr. Probst, this is the petition you read to him word for word?
That is the petition that I read to him word for word. That's correct, Your Honor.
All right, thank you. Now, Mr. Davis, I'm pulling up the part here that has the plea agreement in it. I'm going to read it to you and see if this is your understanding. It says that you're going to plead guilty to counts 3 and 4 of the information. That's 1 count of criminal threat, a severity level 7 person felony, and 1 count of possession of marijuana, a class B misdemeanor. The state's going to be dismissing the other 2 counts. The parties agree, that's your attorney, you, and the prosecutor are agreeing to recommend to the court the standard sentence on count 3, a 6-month jail term on count 4. They're also going to recommend that those counts run concurrently or at the same time, and the state is not opposing your request for probation. Is that your understanding of the entire plea agreement?
Yes, sir.
Anybody promise you anything other than what I just read you to get you to plead guilty today?
No, sir.
Ms. Thibodeau?
Judge, criminal threat is a severity level 9 person felony. Just wanted to correct that. Obviously, that's a lesser than a 7.
Yes.
Oh,
Just want to
that's-
catch that. Yeah.
My
Okay.
apologies. That was a typographical error.
All right. So it says a level 7, but it's not that, it's not a level 7, it's a level 9, which is a lesser crime. You understand that?
Yes, sir.
All right. I got right past there. All right. Has anybody promised you anything else to get you plead guilty today?
No, sir.
Anyone place any threats against you to make you plead guilty today?
No, sir.
All right. Ms. Thibodeau, Mr. Probst, do you have an expectation of what Mr. Davis's criminal history score is going to be?
Your Honor, actually, I don't know that off the top of my head. I'd have to look it up. Tremon, what's your criminal history? What do you have in previous? I don't have that in front of me.
I don't have any over here in Missouri. I was charged at 16 for second degree assault.
Okay, so you potentially have one person felony. Is that correct?
Yes, sir.
Okay, which would make him a D criminal history, Your Honor.
Right. Do you have any information about that, Ms. Thibodeau?
Judge, I'm sorry, I don't have his criminal history in front of me, but the affidavit does say that his conviction from Jackson County was felony, second degree assault, armed criminal action, and unlawful use of a weapon. So I would guess C or D just based off that.
All right. So anyway, Mr. Davis, what happens next after this hearing is I'm going to order a pre-sentence investigation, and they're going to look deeply into criminal history and indicate what they believe your score for the grid would be. Your attorney, the prosecutor, is going to get a chance to take a look at that, see if they agree or if they think there's any errors along in consultation with yourself. And then any sentence you get would be based off of that sentencing grid box. Do you understand that?
Yes, sir.
All right. But for today's purposes, since I don't know what your criminal history is, I always have to assume you have the very worst possible criminal history, so I can tell you the maximum that anybody could get for this crime is, okay?
Okay.
So the maximum that anyone could get for this crime is 23 months imprisonment and a fine of $101,000. That would be 22. Is that 20? I'm sorry, Mr. Probst, is that
Your Honor, that would be
17 months on the level 9 and 6 months on the misdemeanor?
That's correct, Your Honor.
Okay. So the way your attorney calculated this, the maximum for count 1 is 17 months. The maximum for a B misdemeanor is 6 months. You put those together, the most anybody could get for this crime would be 23 months. The maximum fine for the felony is $100,000. The maximum fine for the misdemeanor is $1,000. That's $101,000. And all of this would carry 12 months of post-release supervision. Do you understand those are the maximums?
Yes, sir.
Any questions about any of that?
No.
All right. Do you have any questions about anything that you and I have gone over today?
Not right now, no.
All right. Mr. Probst, do you know any reason why your client should not plead guilty?
I do not know, Your Honor. At this time, I spoke. My client and I have spoken at length regarding the allegations, and I believe that he should. I do not know of any reason why he should not.
All right. Then I'll ask you, Mr. Davis, as to count 3, which charges you with criminal threat, a severity level 9-person felony. How do you plead, guilty or not guilty?
Guilty.
As to count 4, the possession of marijuana, a class B misdemeanor. How do you plead, guilty or not guilty?
Guilty.
All right. I'm going to ask the state to tell me what they think the evidence would be in this case if it went to trial. I want you to listen closely because when they're done, I'm going to ask you if that's what happened, okay? Ms. Thibodeau.
On July 14th of 2020, officers responded to 2026 North 33rd Terrace in Kansas City, Wyandotte County, Kansas. When they arrived, they spoke to a woman named Tiara Ammons. Miss Ammons let them know that the defendant, Tremon Davis, had told her that I will kill you. She was scared that he would, when he said this to her. When the defendant was arrested, there was a search done and they found a green leafy substance in his pocket that was tested and was positive for marijuana.
All right. Mr. Davis, is that what happened in this case?
Yes.
All right. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will in fact find that Mr. Davis is guilty of counts 3 and 4 of the information. Per the plea agreement, counts 1 and 2 are dismissed. I will order a pre-sentence investigation be conducted and continue this sentencing pending the outcome of that. Let me look for a date here. Let's see, 9, 10, 11. I could fit us in on December 18th at 11:30. Mr. Probst,
What was that date again, Your Honor?
December 18th, 11:30.
Judge, I am currently scheduled to be out of town that entire week.
Okay.
So I would not be available. And I'm also going to be gone the 10th and the 11th.
All right, let me back up and look what else I have available.
I would be available the 22nd. I know that's the week of Christmas, but I'm available the 3 days after that.
Yeah, I think I'm all booked up during that week.
Okay.
Looking at the 4th, I know that normally on that Friday, there's a charity bar function, although I don't think that that'll be happening this year.
That is not going to happen this year, Your Honor. I can tell you right now, I'm a member of the board, and we have discussed that is, with the current COVID situation, we are not having that event, unfortunately.
I'm opening up my calendar here, and let's take a look at December 4th then and see what I have left. I've scheduled a 9 and a 10. I could do 11.
That'll work just fine for me, Your Honor.
Ms.
December
Thibodeau?
4th, 11.
That works, Your Honor. The
December
4th at what
4th,
time?
11 a.m. for a sentencing by Zoom. Mr. Probst, does your client have any other holds?
He does not, Your Honor, and he is asking it, at least I'm not aware that he does, but we are asking for a release today on an OR bond since he has accepted responsibility. I did explain to him that his release today, if granted by this court, would be a preliminary glimpse into what he would be doing in his probation, if in fact this court were to grant him probation. So it's kind of a trial run on how things would go, and he says that he understands that and he will be in compliance and be here for court whenever this court sets the sentencing. And then he also, when he's released, he has my contact information, but I'll give it to him again to make sure he contacts me.
Ms. Thibodeau?
Judge, I would defer to the court. It sounds like Mr. Probst already let him know that if he fails to appear for a sentencing or does not or commits a new crime, the state is not bound by their plea agreement.
All right. I'm going to grant your request, Mr. Probst. I just sent you an email with a pre-sentence investigation request that I need you to fill out with the defendant so they can get a hold of him and get his PSI meeting scheduled.
That would be fine, Your Honor. I am waiting for that to come in. It doesn't look like it's come in yet. Can you keep him on for just a minute while I go over that with him? Because there'll be a couple things that, it just came in.
Okay.
Couple things that I don't have an answer to.
Okay. Yes, we'll do that. We'll go off the record. I'm going to grant the OR bond today. Mr. Davis, a couple of things you need to know. We're going to get you out. Here's the deal. Andrews County can't release you there. What they have to do is notify Wyandotte County that you've been released. Or actually Wyandotte County will notify them, and then they have to come and get you, bring you back here and release you from here. Do you have a place you're going to be staying that has a phone and all that?
Yes, sir.
Okay. I'm going to need you. Mr. Probst can get some information. We're going to stop so it doesn't go out publicly here, but he's going to get some information from you so that they can get that going. Let's be adjourned right now. I'm going to end the meeting for everybody. Mr. Probst, Mr. Davis, if you'll stay here with us. I do have another hearing in 4 minutes, so we'll have to be fast.
We'll be very pressed. We'll be
right.
very
Judge, I'll
quick.
leave so you don't have to end the Zoom for them.
Right.
So I'll
That-
just
that-
leave.
That was the idea. All right. Thank you. We're adjourned.